It was just a standard first appearance. We filed a designation which allows his lawyers to appear on his behalf. The matter was put over for 7 weeks to give the Crown a chance to provide us with disclosure. Once we've reviewed that, we'll meet with the Crown and talk about where we go from here.
Explain to the layman how disclosure helps you develop a defense.
I know what the Crown's claiming. I mean, the Crown has made 3 charges. I want to be able to see what is the basis that they're saying those 3 charges are reasonable to make. So it's sort of the underlying evidence or disclosure or documents that they say justifies them bringing the charge.
Can you explain discussions around resolution or what that all means and what might happen? Well,
not so much resolution, but what happens is there'll be discussions with the Crown and the defense about what facts we agree on, if there's things we don't agree on. In other words, we don't, or at least my practice is that you don't go in and fight things that you agree are true. You point out what it is that the issues are, where you differ from the Crown's position and what the defense is, so that the Crowns that are assigned to this case and I have a good working relationship, and we'll talk and just see where we go.
When it comes to resolution, any discussion of a plea at this point?
None.
Is there any possibility this could be moved to a different courtroom rather than courtroom A, just to accommodate us?
Or to accommodate anybody with courtroom A, which is only slightly larger than a phone booth. I would doubt that that's not my call. I don't get to say where it goes, but A court, such as it is where the first appearances are made. And A court is where we'll come back to on the 7th, unless someone tells somebody to do something different, but it has nothing to do with me. I refuse to take the blame for A court.
In cases where there is a lot of public attention, though, are there things the courts can do to make it more accessible?
I don't know. That's not the answer you want.
No.
Certainly, you know, in certain cases they will do that. For example, for a trial or anything, they would, if it was going to attract a lot of attention, they'd make sure you got the largest of the courtrooms. For A court, I don't think they are quite as concerned, because that's more of an administrative court. I mean, I won't say nothing happens in there. I mean, what happens there is important. But there's no evidence, there's no pleas done in A court, and it's a justice of the peace hearing the matter. So because it's more of an administrative process, that's why they use that court. And that's also why we use designations instead of having the clients attend in person. It would really be crowded then.
In Toronto, we've heard some effort is being made to expedite issues because the mayor there, obviously facing his job, is on the line. Is there any chance that, given there's a whole municipality sort of watching this one, that there will be any effort to expedite it, or is there any way for that to happen? Is it up to the Crown for that to happen?
I won't give you the lawyer's answer. I'll give you the realistic answer. No. That's not going to happen. Because there's nothing, unlike in Ford's case, there's something, quote, riding on it, if I can put it that way. In this case, there's not.
And on the 26th, what do we anticipate will take place at that appearance?
One of 2 things. If the Crown and I have had time to talk, we may set a date for a preliminary hearing. If we haven't resolved everything, it'll be adjourned again to allow for further talks.